This morning will be People versus Uhuru.
All right, thank you. This is Justice Huffman. I joined on all the panels this morning with Justice Haller and Justice O'Rourke. So we'll begin with Uhuru. We'll hear from Appellate's counsel first. You requested 8 minutes.
Yes, Your Honor. Jared Coleman for Appellant. This argument was relatively difficult to make. I'm not happy to have even heard about the situation that occurred in the case, but I think that makes the argument stronger in this sense. Was asking for resentencing under a new that would allow him to fundamentally change his sentence. With regard to the Sixth Amendment, that is close enough to trial that would require him to have counsel at every stage, even if he was, quote, guilty. This stage, in this case.
Mr. Coleman, I have a question. Your briefs and your client don't seem to dispute the fact that he's the actual killer. He's the one that shot the victim in the head. No accomplices, no aiding and abetting. So it would appear, speaking only for myself, that as a matter of law, he is not eligible for relief under this section. So the question becomes, let's assume that the court erred in not holding a Marsden hearing. Is that not harmless beyond any reasonable doubt, since your client is absolutely not eligible for any relief under that particular section?
I have to agree that based on the record, I could find no reasonable argument for relief under the statute. So I'm not arguing. I may have to concede the prejudice argument. I'm not doing that formally, but I would have to agree with Your Honor on that. I think still the argument stands that he should. I think the formal argument is this: is that he requested new counsel. His attorney sent him a letter. The court did not request a letter from the attorney, or the attorney didn't send the court a letter with regard to the Marsden motion. I think the proper procedure would be for the defendant to ask for a new attorney, the court to inquire of the attorney, and the attorney to send the justification to the court, because formally that's what that's what the right to counsel is. Even if you're guilty, you have someone represent you before the court. It can't be the defendant's arguments, the failure of whether he has that right. So I would ask the court to find that the trial court erred in not seeking direct advice from counsel, even if it was not prejudicial.
All right, thank you. We'll hear from the people.
Good morning, and may it please the court. Robin Urbanski, Supervising Deputy Attorney General for the People. Appellant entered a guilty plea to second-degree murder as the actual killer. As Justice Huffman noted, he is categorically ineligible for relief under Section 1170.95. Because the record of conviction establishes his ineligibility, the trial court could have denied the petition at the very first step of the process without ever appointing counsel to begin with. If appellant is not entitled or was not entitled to counsel at that stage, then he is certainly not entitled to substitute counsel under Marsden. Even assuming that appellant had a right to counsel or a right to be heard on the Marsden request, his claim still fails. Appellant stated the basis for his request to substitute counsel in two motions to the trial court. He complained that his appointed counsel was incorrect on the law, that a second-degree murderer, even if he was the actual killer, was ineligible for relief. Appellant thought that that ineligibility only extended to first-degree murderers. Well, appellant was incorrect, and appointed counsel was absolutely correct. Appellant was ineligible for relief as the actual killer. He was the only perpetrator of the underlying crime, and he admitted to using a firearm in the course of committing the offense. So even if appellant had been brought to court to be heard on his Marsden motion, it would have been denied because it was based on a faulty premise. So that is one of the conclusions that can be drawn from the circumstances of this case. And the second is that no attorney that the court could have appointed to represent appellant would ever have been successful on the 1170.9 petition, given appellant's particular conviction in this case. So whether this case is viewed from the perspective of appellant's zero probability of success on the Marsden motion, or from his zero probability of success on the 1170.95 petition, appellant simply has no avenue to relief on his claim. If the court has no questions, then I'm prepared to submit.
Any questions from the panel?
I have none.
I have no questions.
Thank you. All right, thank you, counsel.
Thank you.
Mr. Coleman, any further comments?
Your Honor, I think the Attorney General, if the Attorney General is correct and there's no legal basis for relief, the argument still stands, and I think the court should take note that formally deviating from the process of inquiring of counsel is against the principle of Marsden, even if it is, in this case, not prejudicial. And I would request that the court find that the court was in error, even if it didn't, even if there was no prejudice. I think the court should have inquired of counsel. Counsel should have made the request or his statement of categorical ineligibility to the court directly, because the Sixth Amendment demands that in a situation where freedom is on the line. So with that, I'll submit.
All right, thank you very much. The case is submitted. We'll next hear Julian Volunteer Fire Company Associates versus Julian-Cuyamaca Fire Protection District. We have two appellants. Who wants to go first? Mr. Briggs, why don't you go first?
Your Honor, I think Mr.
Yes, Your Honor. I would request to go first on behalf of the Julian Fire Company.
All right. Well, Mr. Sherman, you can go first then.
Thank you, Your Honor. Good morning, Your Honors. Craig Sherman on behalf of the Julian Fire Company Association. This matter comes before you as an appeal from a dismissal of judgment on a motion for judgment on the pleadings. There's really two principal arguments and basis for the appeal. One being the exhaustion of administrative remedies, and second on the statute of limitations. I want to take the exhaustion of remedies issue first. I'll move on to the statute.
Counsel Justice Haller. From
Yes.
my perspective, it will be important for you to talk about the laches argument. I understand that the court did not find on that ground, that she found on two different grounds, but of course you're aware that we certainly have the right to look at that as well on a judgment on the pleadings. So I'll leave it at that.
Thank you, and I can briefly touch on the laches first. I'll move back to my argument if there's follow-up.
That'd be great. Thank you.
You're welcome. My pleasure. The laches issue is it's a question of unreasonable delay. The proceeding before the trial court was progressed based upon ancillary and pendant proceedings. One was before this court on the Southcott case, a matter that would have been dispositive and sent the matter back on the basis of a referendum. As that was pending and it teared up exactly almost when the first writ hearing was promptly scheduled to be heard, and on or about that time, that matter was taken off calendar because this opinion from this court was pending, and that was issued on or about February. So while that appeal was pending in a matter of months, that case was expedited, a ruling was obtained, it was adverse. Petitioners immediately went back to the Superior Court for adjudication. I don't believe that's just unreasonable delay. Secondarily,
Counsel, let me be more specific. There was a hearing set for your writ in this case, not the referendum case, but in this case, to be heard on November the 2nd. And on October 23, you took that matter off calendar. Shortly thereafter, within about 10 days, we have a change in the board, and the board says they are no longer opposed that they are opposed to dissolution. We still have everything going on with respect to the election process, and between October and then we have several months that go by. Your writ on the Brown Act could have been heard, but absolutely nothing occurred until after the voters voted in the special election that they agreed with dissolution. And then it's at that point that your side goes into the court to say, please issue the writ of mandate. And oh, by the way, the association and the district are now aligned. So what I'm trying to focus on is from that time that you had a hearing, you took it off supposedly because and from the referendum, but never did anything to bring it back into the court's attention while an election is going forth with the public. So if you could concentrate on that time period, at least from my perspective, that would be helpful.
Yes, Your Honor. Well, there were two different elections. The litigation for the referendum before the Superior Court.
Yes, I'm aware of that. No,
right.
I'm talking about the election that was triggered because of the LAFCO actions.
Yeah, that election is a different election based on a different type of voting that the petitioners were not trying to obtain. Number one, it looks to people who own certain acres of land, and with the weighted voting, that was not the election for which petitioners were availing themselves of the court to have a proper election based upon the members of the district. So I see Your Honor's point in, while LAFCO's parallel proceeding was going forward with its dissolution type of voting, we viewed this case as being, the right to the decision of the district, which was controlling and affecting LAFCO jurisdiction as two separate complete actions. I mean, the district had its own rights and remedies as its own legislative body, and petitioner was working through that process and not through the LAFCO process. Now, all the parties, including LAFCO, was aware of both proceedings. There had been discussions between counsel. There had been settlement discussions for which, LAFCO counsel was aware of the proceedings of in this action. So we don't see that as prejudicial to the extent all the parties knew exactly what was going on. The county and LAFCO were immensely aware of the Brown Act proceedings and our positions that, if you don't have a valid application, you cannot proceed. So from that awareness perspective, and this is not an immense amount of time. And then the last point on laches, and I'll move on, Your Honor, is that it doesn't apply where these public type of rights are at play. With an administrative law, with respect to the law, it is more of a applicable to private parties, and there's case law on the point. We didn't have the chance to brief it in as much as we did in the trial court, but not on appeal, that it doesn't apply as to agencies who are aware, and when the law is trying to be enforced, that they do follow the law in this Brown Act context.
Right. Thank you very much.
I'm going to be short on time, but I'll move just briefly through what I had thought the primary issues were, being the exhaustion and statute of limitations, with the statute of limitations being fairly strictly a statutory construction question. We believe we're right on that because within the construct of the statute itself, the interpretation of the trial court, and we briefed it well if the court has any questions on it, if you were to not have the agency take an affirmative action, then you would obviate the other subdivisions of the code 54960.1, the subdivisions C3 and C4 would be obviated if you didn't have an affirmative act, which was a rescission and noticed, or affirmative act that we're not going to act to invoke the 50-day statute of limitations. Petitioner in this case filed on the 44th day, which was within the default provision of subdivision C2. On the exhaustion question, we believe that's answered fairly clearly. There was a notice given. The notice appraised the district of the demands for retraction and rescission. Council wrote back, paraphrasing and understanding what was being requested in that notice, and the district ultimately did not come back and rescind or follow the code with regards to the rescission. Argument in the trial court is, well, they didn't write a further objection letter when they continued to proceed with the action. And the main crux of the argument is, we had properly noticed, you were aware of it. When you came back and you should have rescinded, what did you do? The district adopted its further on action to set the terms of conditions for dissolution. It didn't rescind. It didn't follow the Brown Act as to what it's supposed to do with regards to decisions. It's cited in the Boyle case, the Supreme Court references in the Roberts case, and really what needs to be done is you need to rescind. You need to reset. They didn't reset. They went forward with the dissolution proceedings. So those are the primary issues that petitioner raises on appeal, and I'd like to reserve a bit of time for rebuttal, please.
All right, very good. You have about 5 minutes left. Thank you. All right, Mr. Briggs.
Me?
I think we lost.
Your Honor.
There you go.
Briggs, we're having trouble hearing you. It looks like your bandwidth is quite low.
Much of it.
Mrs. Huffman, perhaps we should ask Mr. Briggs to call in, because it's showing that he has a poor network connection.
Mr. Briggs, why don't you pick up the telephone and call in on the number that they've given you? Your video is not working. Why don't you call in on the telephone, Mr. Briggs?
I'm doing so right now, Your Honor.
Thank you.
Perfect. Thank you.
Hello, this is Corey Briggs.
We can hear you.
Okay, may I proceed, Your Honor?
Justice Huffman, can you hear Mr. Briggs?
Well, speak up, Mr. Briggs.
Hello, nurse. Can you hear me now?
I can hear you now.
Yes.
Okay, I apologize. Let me basically start over with may it please the court. I think the briefs are thorough on the issues. I don't want to spend time on the propriety of request for judicial notice unless the panel has questions, which I'll be happy to answer. What I do want to focus on is the narrow issue that my client's appeal presents, and that is whether a public agency that cures an alleged Brown Act violation is entitled to have the lawsuit dismissed with prejudice, even with the lawsuit pending. We think those are straight cases of statutory interpretation where the statute is not ambiguous, which means the court simply has to apply the law as written. Under Government Code Section 54960.1a, there's nothing that prevents an agency from making a cure. And under subsection E of the same statute, when the legislative body of the agency makes the cure or correction, the action shall be dismissed with prejudice. That's mandatory. the subsection A doesn't require any sort of special compliance. Even if it did, there's a presumption of compliance, which has to be refuted by the party opposing it. So we think that the issues raised by the Volunteer Fire Association are actually moot because the lawsuit simply should have been dismissed with prejudice once my client submitted the resolutions showing that the cure had occurred. At that point, the trial court should not have reached the motion for judgment on the pleadings, even though they were scheduled for the same time, because the matter has to be dismissed with prejudice. If there are questions, I'm happy to entertain them, but that was what I wanted to emphasize, that the agency always has the right to cure a lawsuit at any time, and at that point, the lawsuit has to be dismissed. Thank you.
Are there any questions from the panel?
No.
Apparently not. Thank you, Mr. Briggs. You have time to respond. All right, well, let's hear
Thank you.
from the respondent, LAFCO.
Good morning, Holly Watley on behalf of San Diego LAFCO. I want, as always with the oral argument, you have your remarks prepared, but I want to focus in on what was of interest to the panel, and that is the latches argument. The district is claiming, of course, that it had the ability to cure and that the action should have been dismissed based on that cure. However, the trial court actually, in denying that motion to dismiss, although the court did not use the language latches, in fact, the last substantive paragraph supporting her ruling on denying the motion to dismiss goes through and cites, in fact, facts supporting the delay that the district engaged in. They did indeed have already scheduled a trial on the Brown Act action for November 2nd, and for whatever reason, they took that off. Their prior appeal on the referendum of the resolution of application demonstrates that the association knows how to go in ex parte to try to set something for hearing before agency action is taken. And they deliberately chose not to do that here. They waited until after LAFCO held the hearing on the application and granted it. That happened in September. They waited until after the protest hearing, which was in October, just before what would have been the November 2 trial date. They did not seek to get a decision before the protest hearing. They did not seek to get a decision before the county called the election, nor did they seek to get a decision while the election was pending. They waited until 2 weeks after the voters had confirmed the decision. And so while latches, the concepts of latches and estoppels normally are applied with some reservation against public agencies, case law is clear that you nevertheless may still apply them against a public agency if there has been significant detrimental reliance on that action, and that is what happened here. It's not just LAFCO's reliance. It is not just the county's reliance. It's the voters. It's the voters' reliance. So those factors supported the trial court's, among other reasons, trial court's denial of the dismissal. And so that, in fact, the district did not have the ability to cure without running afoul of latches. A couple of other points in response to the argument from the association. And just to be clear, the election that took place that was triggered by the protest proceedings was an election of registered voters in the district. The protest proceeding, which took place in October, which triggered the election, that in fact is one where it's based on the number of registered voters that protest, or also landowners based on a weighted acreage of their land within the district. But once that vote was triggered, it went to the registered voters, the very same election that they were looking for and wanted. And it was only when the outcome of that election was against them did they begin to sort of scramble and in fact actually collude together without alerting the trial court to that they wanted to have an unopposed trial, to have judgment entered against the district, which the district did not oppose, exposing itself to claims for hundreds of thousands in attorney's fees, and then within 24 hours or possibly less of obtaining that collusive judgment, engage in what they purported to call a cure. The trial court did have before it sufficient evidence. The district argues that the trial court should have granted their motion that they did not need to establish compliance with the Brown Act in relation to that cure. And they cite an evidence code 664 as a presumption. But that presumption is rebuttable, and the court had all the evidence before it needed to reasonably conclude that that was rebutted, and they needed to affirmatively show compliance with the Brown Act. That one point illustrates, really, it encapsulates sort of the I would call it a hall of mirrors that essentially is what appellants argue here. They're hoping to distract. They tried it with the trial court, and they're trying it here with a hall of mirrors, somehow claiming that, for example, the district back in February, March, and April of 2018, well, the court can't decide whether there was a cure then. But later, now when the district engages in actions, now the court does have the power to find a cure. As another example, on the cure and the letter asking for a cure back in March, somehow they're asking this court to say, even though that letter alleged a secret agreement to restrict a board member from participating in decisions, they somehow argue that that letter, dated March 9, alleging that secret agreement, applies as an adequate demand to cure actions that took place after that letter and then involved secret agreements other than what was alleged. I think the height of the hall of mirror issue is the district claiming that it has standing because it somehow is aggrieved by a judgment in its favor, finding no valid Brown Act claim, relieving it of any obligation for attorney's fees, that somehow a ruling in its favor, they are aggrieved by it, and they can come to this court. They would presumably be happier with a judgment against them, exposing them to fees. Collectively, the arguments are essentially a heads I win, tails you lose. And the trial court didn't get lost in that hall of mirrors, and she determined that there were irregularities that prevented the parties from having a fair trial. And among the irregularities, of course, are the last-minute requests to have an expedited trial. So on the Friday before the Monday where LAFCO's action was taken to receive the certified vote results and complete the dissolution. Unless the court has any questions of me, I would go ahead and allow my colleague his turn.
There appear to be no questions. Thank you.
May it please the court, Your Honors, this is Joshua Heinlein appearing on behalf of the county. I don't have any additional points in addition to what Ms. Watley just reiterated. I am here in case your honors have any questions specific to the county, but otherwise I will submit based on Ms. Watley's arguments.
All right. Does the panel have any questions of Mr. Heinlein?
I have none.
I have no questions.
Thank you. All right, and we'll go back then to Mr. Sherman. You have about 5 minutes left.
Thank you, Your Honor. The first point on the laches, it wasn't unreasonable delay. The case was timely filed. Laches is about 99.9% of the time, and we did brief it in the trial court, applied when a party delays in bringing a case and it's used as an equitable defense to a statute of limitations. The fact that the case was filed and took 9 months or a year in a civil case for which there were discovery disputes, there were ongoing efforts, there was pushback, that's briefed in the trial court, supported by my declaration, supporting facts for that. And Ms. Watley's characterization of at the last minute coming back before, the LAFCO made its decision, our timing availing ourselves before the trial court was based upon the unsuccessful effort in the referendum appeal before this court, which we felt very strongly about, that the decision to rescind was and proceed with dissolution, not rescind. Proceed with dissolution of the district was a legislative act. It seemed like it on its face, very credible case, did not come out the way petitioners sought, but obviously put a lot of lock, stock, and barrel in those arguments. This court found it was administrative and LAFCO jurisdiction prevailed. But that's not to say that it wasn't a correct or reasonable belief that would have mooted out the necessity for a trial in the Brown Act case. That's why there was delay. And that was put forward before the trial court, supported by declarations and supported by dates. On early March 9 or 10, when this court issued its ruling in the Southcott case, we proceeded within days to proceed before the trial court because we did know it was imminent. Look, that effort was not successful. That was the reason for holding back and proceeding to trial. And now was the time to bring it before the trial court, which we did. We moved ex parte. We moved ex parte for two reasons. One, because it was now for the forefront and needed to be brought forth, and because LAFCO proceeding their effect with the timeliness issue. And that's when we brought it before the trial court, there was full notice. There was no collusion, did not try to pull a fast one. If you look to the sections in the briefs and supported by the record and the papers presented to the trial, we directly said that the reason for the exigency was the parallel proceeding. And it was briefed, it was in my declaration, it's before this court. So there was no collusion or undue effort or trying to hide anything. But the timeliness makes sense within the context of civil litigation, the proceedings, and the necessity for when it was brought before the trial court. Meanwhile, LAFCO and the county are aware of the proceeding. They had been all along, as I stated before during my argument. They were writing letters to the district. They knew that the board had changed, that there was an admission or change in heart, that they knew there were some undue processes, Brown Act violations. The evidence we present, we're not talking about the merits here on appeal of the Brown Act claim because...
Counsel, excuse me. Let me ask you a question from a very practical standpoint. Let's assume we agree with you that the court erred in granting judgment on the pleadings, and we go back, you go to trial, and you prove your Brown Act violation. Then what happens? We have a public that has said they want a dissolution. So where does this take us? Does it take us to the issue that there was theoretically a violation and therefore attorney's fees are appropriate? Where is this taking us?
I think plenty of precedent, Your Honor, the fact that the voters vote, they enact, government takes an action, and things are rescinded or undone. because of some legal undoing. Yes, it would be unfortunate, but isn't that the impetus for this case was based upon, and we've argued in our brief, the fruit of the poisonous tree, where it will undo action by the board, and this would have never happened but for this Brown Act violation. And we think the Brown, in this instance, sits at the top of the hierarchy with regards to this couldn't have occurred.
So as between Brown Act and the public voting, you say basically that the Brown Act has more panache and therefore it wins.
I didn't mean to say it that way. What I meant to say is there wouldn't have been impetus for dissolution if the law was followed because it had failed for 15 years. If there wasn't collusion doing by the board of directors to proceed with decision, wouldn't be here but for that. We do believe in that sequence of events, the Brown Act does sit at the top of the hierarchy. With regards to undoing the public process, it's not much different from undoing a referendum at the state level. They have to be constitutional. Sorry, voters, this wasn't going to happen because this is an important law. There's a problem with this in one way or another, and that's the court's province to undo and fix. And we believe that we were timely, we were right, presented it to the court, but for the counties, we argue, battling with the district to get the people on the board, to negotiate the terms in advance, to somehow get that through the jurisdiction, it wouldn't happen but for that, and it does warrant rescission in this case.
All right.
So I'll submit on that, Your Honor.
Thank you very much, Mr. Sherman. Mr. Briggs, do you have any further comments?
I do, Your Honor. Can you tell me how much time I have remaining, please?
You have about 10 minutes.
Okay, thank you. So I want to call the panel's attention to Resolution 2019-02, which was included with my client's motion to dismiss. The panel should keep in mind that we're actually trying to give voter intent on two matters, not just one. The first one was the election of a new governing board in November of 2018. That board took over, was sworn in December of 2019, and they proceeded to change their attorneys. My firm subbed in on March 18th of 2019. If you look at the resolution, you will see that the board wanted to independently cure and correct. It eventually did so, the same time that it was responding to the trial court's original writ to do so. And that's spelled out in the resolution. What LAPCO and the county are doing is trying to rebut what is in the resolution, which was properly evidence, with matters that are subject to judicial notice, which doesn't get to the truth of the items asserted therein. And furthermore, they have to provide admissible evidence to rebut the presumption under Evidence Code Section 664 and the general presumption of compliance with the rules. Furthermore, we have the Brown Act provision that says nothing in this chapter, nothing in the Brown Act prevents a cure and correction. So my client's concern is that we're jumping to the end, which is the subject of the related lawsuit and the related appeal. And in order to jump to the end, we have to misconstrue the Brown Act and misapply rules of judicial notice. And that would be a problem. Justice Haller raises a really good point about, what about this issue of attorney's fees? If there's a dismissal with prejudice, there's no automatic entitlement to attorney's fees. The petitioning parties would have to show that they still meet the requirements for that. And as resolution number 2019-02 indicates, the board wanted to cure this anyways. This wasn't because of a lawsuit, it's because a new board was elected. So if we're going to give meaning to voters' choices, the court needs to give meaning to the voters' choices to replace the old board and put in a new board that wanted to implement a cure and a correction. And then the right place to deal with the consequences of all of that is in the other matter. But we shouldn't distort what the Brown Act says clearly on its face and upend, decades of very clear rules about how we use judicially noticed materials in order to skip steps just to get to the end. I'm happy to answer any other questions, but with that, I'd be happy to submit.
All questions from the panel? Apparently not. All right, thank you, Mr. Briggs, and the case
Thank you, Your Honors.
case is submitted. We have two cases that follow, Robertson versus Vu and Suprovici versus Vu. We did not consolidate them, but we're going to hear the arguments together. So for the appellants in both parties, we'll hear from Mr. Robertson first, then Mr. Suprovici after that, then we'll hear from the respondents, and then the appellants will have an opportunity for rebuttal. So we begin with Robertson versus Vu.
Good morning, judges. This is Michael Robertson. Can you hear me?
Yes, we can hear you.
Great. Thanks for the opportunity to speak in this case. This case is about a demur in an election contest, which is not allowed by the statute or case law. I'm in front of you asking you to vacate that demur and to set aside the election. But first, I want to tell you how the case started, because I think that's illustrative of the core issue. So I went to file this case, and there's a cover sheet that you must fill out, CM010. And I submitted it to the administrative clerk and put on there that this is an election contest. And she says, no, you've got to check the box for a civil case. I said, but this isn't a civil case. This is a different beast. She says, no, it's a civil case. So I reluctantly checked, okay, it's a civil case. Then she said, no, this is an unlimited civil case. And I said, but I'm not asking for money. Isn't that the defining? She says, no, this is an unlimited civil case. So I paid the extra $200.
Sir, Mr. Robertson,
Yes.
I just want to make sure all of this took place after the election, correct?
That's correct.
All right, thank you.
That's correct. So I checked unlimited and put it in there. And that illustrates that this process of a special proceeding, which an election contest is foreign to the administrative clerk, the court clerk, and even the judge. An election contest is a special proceeding, and all the rules are laid out, and the process is laid out, I should say, in Division 16,000. And it's quite simple, right? You file the action, and then I forgot to mention that the court clerk said you need to serve the other party. But that's not how it works in a special proceeding. In a special proceeding, the court clerk asks the sheriff to serve the citation. And so what you see is that the court is forcing it into a civil process when this is a very different process. It's a very quick process, right? There's 5 days for the court clerk to serve the defendant. Then the judge sets a trial date 10 to 20 days afterwards. Then the trial happens. That's it. I tried to explain to my kid what was going on here, and he says, Dad, you're getting ghosted. And what he means by that is that I'm explaining to everyone in the process, hey, this is a special proceeding. It's different than a civil case. And that is completely not mentioned in any of the district court's ruling. And I suspect that Denny felt the same way because it's not addressed in that case either. Now, I found a highly dispositive case, a California Supreme Court case that I want to bring to attention that's not in the briefs. It's O'Dowd v. Superior Court, 158 Cal 537. And it goes into great lengths to reinforce each step of the process, which I just quickly, cursorily covered. But it also talks about the process goal. In that, they use the word speedy 3 times, describing the intention of election contests is to speedily get through the issues, have them heard on their merits. Well, I'm in front of you 2 years after the election, and so the opposite has happened here in this case. And I think, in my mind, that vividly illustrates that in a special proceeding, it's completely incompatible with a demur and the other CCP process. And I would add that was a conclusion in Dorsey as well, when that court found that the district court had no jurisdiction to hear motions. So the second point I want to make is that the defendants have a ministerial duty to follow the law. In this case, it means, number one, they must only print and circulate ballots that conform to the law. Number two, they need to reject ballots which do not conform to the law. And finally, the county council needs to author an impartial analysis of this measure. Now, the registrar conducts many types of elections, candidate elections, recalls, citizens initiatives, and by most accounts, they diligently follow the law in those cases, ensuring there's legal and honest elections. And of course, all of you have firsthand experience as you are elected officials. And I would ask you the following. What would happen if I applied to be on the ballot as an appellate court judge? I'm not an attorney. I don't have that legal experience. Would the registrar allow it? Absolutely not. They would bounce it. But this raises the question, why is the registrar diligently overseeing some elections, but completely abdicating their duty with ballot measures? Well, we don't need to speculate because defendant Vu told a reporter exactly why, a reporter that's covering this case. He said, quote, he is not responsible for reviewing ballot language submitted to them by other governing bodies. And that's the reveal. There are two sets of rules here. One, if citizens want something to be on the ballot, the registrar is very proactive in making sure that they conform to the law. But there's a different set of rules if a government agency does that. That's unjust, and there's no basis in law for it. And concerningly, the government agencies, they've realized this, and that's why their corruption is growing bolder and bolder with every election cycle about the kinds of ballot statements they're submitting to have the registrar print and distribute. Now, I will add one final point on this. The defendants repeatedly claim that they do not have the right to change the language of a ballot measure. And that may be correct, but they ignore that they do have the duty to reject a petition that does not conform to the law. That's the point in Myers v. Patterson. And so the summary is defendants are clearly not performing their ministerial duty. My next point is the following, and this one's probably the most frustrating. The defendants repeatedly mischaracterized issues being raised as, quote, alleged technical deficiencies or, quote, errors. That grossly mischaracterizes my position to the point of dishonesty, I believe. I'm not alleging there's a technicality or an error where there was a typo or they used who instead of whom. No, my claims are they are clearly violating major requirements of the law for ballot measures, none of which are errors or technical deficiencies. These are intentional acts. And those intentional acts are repeated, ongoing, and they lead to corruption. The biggest, of course, is that they're using partial and prejudicial language in violation of 13119C to promote the measures, passage. And there are many other violations that I won't review. They're in the briefs. When you're looking at ballot issues, the California Supreme Court case Right Out is really the cornerstone and tells us there are two different categories. There's directory and mandatory. Directory are the more minor issues. Those are the technicalities or the errors that the defendants have referenced. But the other category is mandatory. How do we know a mandatory issue? Well, Right Out gives us that test. And what it says is the following. If the act enjoined goes to the substance or necessarily affects the merits or results of the election, it is mandatory. Well, it's hard to imagine anything more substantive or which would affect the results of an election more than the 75-word ballot statement. That small block of language which most voters rely on, and maybe the only thing that they read to make a decision, that has now become a sales brochure. And Right Out further goes on to say, a violation, quote, a violation of a mandatory provision vitiates the election. Now, I have to admit, I had to look up the word vitiate the first time I saw it. I know it sounds bad, and it is bad. It means destroy. And it's why our request to set aside this election is justified and appropriate. But curiously, you will not find the terms directory or mandatory in any of the defendants' papers, because even acknowledging that distinction and having this case judged on the merits would vitiate their defense. Nor did Denny up in San Francisco address this issue as well. My final point. much hay has been made about their claim that they cannot be defendants. And they point to 16002, which has a definition for defendant. Defendant means that the person whose election or nomination is contested. They say, we're not running for election, therefore we can't be a defendant, therefore you can't bring this election contest. That's their claim. But statutory construction requires looking at the plain language to discover the original intent. And the obvious intent, if anyone looks at Division 16,000, is that people should have the right to challenge any election on any cause. I would point to 16100, and it reads the following. Any elector of a county, city, or of any political subdivision of either may contest any election held therein for any of the following causes. That's 4 any's. Any election doesn't just mean candidate elections, but also recalls, initiatives, and ballot measures, what we're bringing at. I think there's another very important section to look at in that 16400. 16400 describes the 5 elements you need to file an election contest. Element number 2, defendant. If the defendant's view is applied that only a person whose election or seeking an election or nomination can be a defendant, well, then it would be impossible to bring any election contest against any non-candidate election. Back to O'Dowd, that case I mentioned earlier that I think is wonderfully dispositive. Here's a quote from O'Dowd. Quote, as the obvious purpose of the statute is to have these contests determined on their merits, no construction should be given to any of its provision which will defeat that end. Just reinforcing the importance of the statutory construction issues here. And finally, I'd point out very quickly, there are many election contests which have gone all the way to the California Supreme Court challenging ballot initiatives, some of which have even had the registrar as defendants, Canales, Enterprise, Rideouts, O'Dowd that I mentioned, and there's hundreds more that haven't gone to the California Supreme Court. But Canales, the one that's in our papers, specifically found that 16100C, which is the basis of our election contest, could be the basis for a ballot measure contest. Finally, I want to leave the court with a very quick analogy. Imagine if somebody put on every voting booth in San Diego County a bumper sticker that said, vote yes on MM. It's for the children. Under the defendant's construction, that election could not be contested because there's no candidate involved. It's an absurd conclusion, and it eliminates the people's rights to challenge elections. And I'll also add that hypothetical that I just mentioned, it's not so much a hypothetical because it's actually happening. Only it's not a bumper sticker on the voting booth. It's in that 75-word ballot statement that is so partial and prejudicial. 13119 is a new law as of 2018. It's designed to stop the election abuses with these local ballot measures. But if the law is going to mean anything, we need it to be enforced, which is why I'm asking this court to vacate the demur and set aside the election. And if setting aside the election is not appropriate, then order the district judge to have a special proceeding and give this case its day in court. Thank you.
All right, sir. Thank you. All right, Mr. Suprovici, you there? I've probably messed up your name.
There we go.
Yes, sir.
Can you hear me okay?
Yes.
Give us your name for the
Roswan Suprovici is my name, and as you can tell, I am an immigrant. And while growing up in communist Romania, my grandfather used to tell me that there was a place called California where the palm trees grow and people vote their desires. I am here today with no incentives besides a hope that we uphold the law against dishonest election ballots. Every homeowner in San Diego was signed up to pay an extra $11,346 per median-sized home through this election. That is equivalent to the cost of a vehicle. Would the ballot statement qualify as a fair purchase contract? If you were to drive out of a dealership with an $11,000 car, not knowing the rate of your loan, agreeing to a vague description akin to something on four wheels, and no fine print. This is all that the voters got. There was no ballot measure. Measure YY was the first school bond in history to exclude the ballot measure. The text describing what you're getting from the voter pamphlet. Michael Vu was instructed to print the full text of the measure in the voter information guide, and without any statutory authority, decided not to print it, denying the voters the requirement that they be given the measure before they vote. This is a special proceeding, not a civil action. Dorsey and all other succeeding cases in special proceedings until Denny have held that the trial court has no jurisdiction to consider typical CCP provisions, such as CCP demurs. When a court acts outside of its special proceedings provided by the legislature, it acts without authority, and accordingly, its acts are void. Finally, according to Denny and counsel, no one would be able to contest the election. Despite the clear violation of the electioneering prohibition in Election Code 18370 and 18371, and express legislative command that any ground applies to any election. I request that the Court of Appeals order the district court to follow the rules of special proceedings as required for election contests. Thank you.
All right, so thank you. All right, I hear from the respondent. You can argue both cases.
Thank you. May it please the court. I just want to back up for a moment and just reiterate.
Your name.
I'm sorry?
Your name for our record?
I apologize. This is Christina Snyder, and I represent the Registrar of Voters and County Council of the County of San Diego.
Thank you.
Thank you. So I just want to back up for a moment and remind the court that all of the issues that the plaintiffs have brought to the court's attention and that they are contesting are technical defects in the ballot materials that should have been brought prior to the election. And I think that's just the overarching theme here. The third and fourth causes of action of both of the cases that allege that the measure text did not comply with Proposition 39 do not lie against my clients, against County Council and the Registrar of Voters, because they did not write the measure. But all of the rest of the causes of actions and the allegations just are something wasn't capitalized, or it's missing or it was a few words over. The ballot text was a few words over what it was supposed to be. They're minor technical defects that you cannot bring post-election. You can only bring those prior to the election. There is a statute that authorizes that, and these errors should have been brought prior to the election. They could have been worked out at that time. After the election, there is no statutory authority for this type of cause of action. It's not an elections contest. And Mr. Robertson has said that the court improperly categorized this case initially. And while we will not take a position on that, I will say this is not an elections contest in its substance. So it does not matter if there was something wrong with the civil case cover sheet initially. This is not an elections contest. This is a claim that should have been brought pre-election. It does not fall under the rubric of Elections Code 16100. We also just want to point out, we disagree that there was any corruption, obviously, between the school district and the county. The Registrar of Voters does have a ministerial duty when elections are consolidated to put something on the ballot. And all of the alleged errors that both of the plaintiffs are claiming do not rise to this level of, something that he should have taken note of or done anything about. So I just want to point out that obviously we would disagree with the contention. Corruption among the government agencies, obviously. And reiterate that that my clients are not proper defendants under 16002, and that only candidates that were in the election would be proper defendants. I understand Canales did say that a measure could be contested. However, in Canales, the plaintiffs were requesting a recount, and they were saying that there was some bribery that occurred by the defendants, and that's not at all what is. That's not at all what we have here. The allegations we have here are that there are alleged technical defects in the ballot materials. And finally, with regard to Measure YY, which is Mr. Suproviči's case, the resolution from the school district did authorize the registrar to not put in the entire full text of the measure. So that just to clarify that. So we did have that authority from the school board, the school district's resolution. But I don't want to belabor all of the points that I've already made in my briefs, so I will just ask if the court has any questions. I'd be happy to address them.
Does the panel have any questions?
I do not.
I have no questions.
All right, thank you very much. Thank you, counsel. All right, Mr. Robertson, I'll give you about 3 minutes. You've used most of your time.
Okay, thank you, Judge. I don't have a lot to add other than the defendants repeatedly say these are technical issues, but it's not technical issue when it goes to partiality and prejudicial nature of the ballot statement. We go through painstaking details in the brief to outline how—
Mr. Robertson, let me interrupt. This is Justice O'Rourke. County Counsel said your remedy was to bring an action before the election, and you have no other remedy. Would you please comment on that for us?
Well, that's not, nowhere in the law does it say that. And I find that really a preposterous claim. It's like saying to a domestic violent person, you have to file a restraining order if you want to file assault charges after the fact. Those are two separate things. Yes, you can file a writ in advance if you rush to court in 10 days and have the time and the attorneys and try to get something through there. But that doesn't preclude you from filing an election contest. There is nothing in the law that says that. So I think that claim is simply false.
Okay. Anything else, Mr. Robertson?
No, judges. Thank you.
All right. Thank you very much. Mr. Suprovici?
Hey, thanks. I'll be quick as well. I would like to ask, the council said that it says it's written in the law that the complaint must be brought before the election, and I would like to see I would like you to ask the council where in the law that requirement is stated, because it's clear to us that it's not in the law, and that it's fully 100% okay to challenge the election afterwards, and it's actually very much in line with special proceedings as we've described previously. Furthermore, on the question of not printing the ballot measure, it's not up to the school district to decide whether they want to print the measure or not. It's on the voters to decide if that's they need to see what's being voted on, and that's a matter of law. That's how every single measure is required. And the defendants, Michael Vu, his job, what he's sworn to do, is to ensure that that ballot measure is printed. And if the school district desires that it's not printed within the ballot, then Michael Vu's job is to push back and say this is a requirement. That's their only job, is enforcement of the law. Imagine where would this court room be if nobody was enforcing law, right? This was the job of Michael Vu and Mr. Montgomery, and they chose not to do their law, and that's why we're here today. Thank you.
All right, so thank you very much. The case is submitted. The court will be in recess until 1:30.
Thank you. Officer Reynoso, Justice Haller, we are just about a minute before 1:30. Would you be good enough to call court into order?
Yes, Your Honor. The 4th District Court of Appeal, Division 1, is now in session with the Honorable Judith Haller presiding. We ask that you please mute your microphone and turn off your video camera until your case is called. The first case this afternoon will be McCarley versus ASMG. Thank you.
All right, thank you. And just so everyone knows, we have 3 cases on the calendar, and we will have 3 separate panel changes. I will be presiding at each one of the cases today. And before we begin with McCarley, I would like to welcome and say to everyone, I am joined today by Justices O'Rourke and Justice Doe. And Justice Doe was confirmed to our court maybe 2 months ago, and this is her first oral argument. So welcome, Justice Doe. We're very pleased to have you with us. All right, then.
Thank you, Justice Haller.
Okay. Let's hear then from Appellate's counsel in the McClary case. And counsel, please, Mr. Dixler, make your appearance for the record.
Good afternoon, Your Honors. May it please the court. My name is Scott Dixler. I represent the defendants, Dr. Canada and Anesthesia Service Medical Group.
All right. And Justice O'Rourke and Justice Doe, can you hear Mr. Dixler okay?
Yes.
Yes.
Okay. All right, fine. Then let's begin. Thank you, sir. And how much time would you like to reserve, if any?
I'd like to reserve 5 minutes for rebuttal, Your Honor.
All right, that'll be just fine.
Your Honors, the judgment in this case should be reversed with directions. And the reason for that is that medical malpractice liability as a matter of law is unavailable and improper where there's a debate among physicians as to medically accepted methods of treatment. The paradigmatic medical malpractice case involves a mistake. A physician makes a mistake, and the question for trial is then whether that mistake was reasonable or unreasonable. But here, it's undisputed that Dr. Canada didn't make a mistake in connection with his treatment of Ms. McCarley. To the contrary, Dr. Canada did exactly what he set out to do when administering anesthesia. Dr. Canada adheres to a traditional view among anesthesiologists that the safe lower limit of autoregulation, which dictates how low an anesthetized patient's blood pressure can fall, is a mean arterial pressure of 50. And he proceeded to administer the anesthesia with that in mind. Now,
Counsel, it's Justice Haller. You seem to be arguing that as a matter of law, he could not have been negligent. But isn't there quite a bit of contradiction as to whether the level of 50 is appropriate or not?
Yes, Your Honor, and I'll answer that in 2 ways.
All right.
So he's not liable as a matter of law, but it can also be viewed through the lens of substantial evidence. In other words, the other side in their brief cites the substantial evidence standard of review, and they point to expert testimony that they introduced that, as Your Honor referenced, shows that some doctors believe that the lower limit of autoregulation is higher, is a mean arterial pressure of 70. But under the substantial evidence standard of review to prevail at trial and now on appeal, Ms. McCarley had to demonstrate that no reasonable physician would adhere to the traditional view, the 50. And the debate among physicians that Your Honor references, as a matter of law, defeats the verdict. The very existence of the debate, the very existence of the fact that reasonable physicians could adhere to one view or the other. And it's important to connect.
This is Justice O'Rourke. Where do we find evidence that there are these 2 standards of care in this record?
So I'd point, Your Honor,
for Ms. McCarley rejected that out of hand, said that that was archaic, antique thinking, that a mean of 50 was appropriate. Was that not the testimony?
It wasn't precisely the testimony, Your Honor, and in this context, I would direct the court to look very closely at the testimony of Dr. Wilson, who is Ms. McCarley's expert, and then the materials that Dr. Wilson relied on. True, as Your Honor said, Dr. Wilson testified that the standard of care, in his view, required a mean arterial pressure of 65 or 70. That's what he did say. But He acknowledged, first of all, and this is that volume 8 of the reporter's transcript, page 1305, Dr. Wilson acknowledged that there was literature out there supporting the traditional view where which holds that the mean arterial pressure can be 50 and that is a safe lower limit.
Didn't he say that was archaic, something that dated back several decades?
Dr. Wilson
no longer the prevalent standard of care. Isn't that basically what his testimony was, sir?
What Dr. Wilson said was that he based his opinion of the 65 to 70 on the Miller's textbook. And the Miller's textbook does say that more recent data supports a view in the Miller's textbook author's opinion that the lower limit of autoregulation is 70. And so clearly Dr. Wilson and the Miller's textbook recommend that physicians follow the 65 or 70. But what the critical thing is that both Dr. Wilson and the Miller's textbook on which he relied also says it acknowledges that there's a traditional view of 50. Now, as Your Honor mentions, the textbook, Dr. Wilson, they say, well, that view is outdated. But nonetheless, they acknowledge the existence of that view and say that it's widely reported. And as a matter of law...
Well, I think the problem that I have is if it's largely rejected now by the discipline, and that's certainly the impression one gets from Dr. Wilson's testimony, I'm sure that there might have been a time where there might have been a prevalent view. But was there any testimony as to how many people other than your client adhered to the 50 level?
Your Honor, there wasn't testimony that was trying to do a head count of doctors. The testimony was, as I mentioned, that the plaintiff's evidence, Dr. Wilson said, well, the standard of care requires 65 or 70, but there is this view out there, the traditional view of 50, which he disagreed with, but acknowledged.
Well, shouldn't we call it the formerly traditional view? I mean, it's decidedly a minority opinion, is it not?
I think that's fair to say that it's not the majority opinion, but that the law doesn't require that physicians adhere to the majority opinion. The law insulates physicians from malpractice liability.
I understand the standard perfectly well.
Okay, Your Honor. So
I'm actually more interested in your 998 arguments.
Yes, counsel, I think that there's considerable question among the panel on the 998. And so you can choose what you want to focus in on, but we'd certainly like to talk about that.
No, I'd be happy to address that, Your Honors. Under the law, a Section 998 offer to be valid has to offer to fully resolve all of the claims against the offer, the recipient of the 998 offer. But McCarley's 998 offer to Dr. Canada didn't do that. It offered to settle, quote, your several liability only. But that offered to settle only a portion of the case against Dr. Canada. Dr. Canada, under Proposition 51, faced several liability for McCarley's non-economic damages, but he faced joint and several liability in connection with her claim for economic damages.
Counsel, this is Justice Doe. Didn't the defendants in the trial court assert, and I'll quote from the Memorandum of Points and Authorities filed in support of the motion to tax costs, this is at page 2, quote, on March 24, 2015, counsel for plaintiff McCarley made a Section 998 offer to compromise, offering to dismiss defendant Edgar Canada, MD, in exchange for the payment of $1 million. Canada did not accept the offer. So from that, it would appear that the defendants not only failed to raise the ambiguity issue advanced now on appeal, but that there seemed to have been a unified interpretation of the 998 offer that acceptance would result in the dismissal of Dr. Canada from the case. How do you square that with the position you're now arguing?
Your Honor, the issue is on the face of the 998 offer, what does it mean? And it's just the cases say that ordinary principles of contract interpretation are brought to bear to determine what a 998 offer means. And critical here is the principle that 998 offers are strictly construed and any ambiguity is resolved against the 998 offer. So here, just looking at the four corners of the 998 offer, where it offers to resolve, quote, your several liability only. At best for McCarley, that's ambiguous. And that
the word only, I don't think was in the offer, was it?
It was, Your Honor. I would direct the court to volume 1 of the appellant's appendix, page 38A. I have that right here.
It says only several liability.
Yeah, I can read it to the court if
yeah, why don't you, please?
Sure. What it says is McCarley, and I'm now directly quoting, it says, hereby offers to compromise the above entitled action in the amount of $1 million for your several liability only and not for a discharge of any other defendant's liability.
Counsel, if I can direct you to what was a portion of Justice Doe's question. In the trial court, this issue of ambiguity was not raised, correct?
Yes, that's correct.
So and I understand clearly the proposition, we can look at issues that are legal only, different theory on appeal. But here we have the plaintiff's attorney saying, look, I gave them the 998 and I had a letter that told him he was going to be dismissed. So would you talk about the forfeiture issue, please?
Sure. So as Your Honor mentioned, the pure issues of law can properly be considered for the first time on appeal, and the proper construction of a 998 offer, like the 998 offer in this case, is a pure issue of law that this court can review even though it wasn't brought up in the trial court. Ideally, it would have been, but it wasn't. That's not an insuperable obstacle to this court's review. In terms of opposing counsel's argument about a letter that's outside the record, the key issue there is that it's outside the record. So for the purposes of this court, it doesn't exist. It can't form a basis of this court's.
I think his point is, had you raised, not you, but had your client raised the ambiguity issue at the trial court letter, he then would have brought to the court's attention this extrinsic evidence vis-a-vis the letter.
Yeah, and to address that head on, Your Honor, I don't think that anything about that letter changes anything. The key is what does the 998 offer by its plain terms mean? The most natural reading of the 998 offer is that it offered to resolve part, but not all, of McCarley's claim against Dr. Canada. But at best for McCarley, just reading it under its own terms, where it offers to resolve, quote, your several liability only, it's at best for McCarley ambiguous. And regardless of whatever other letters there might be, but just looking at it on its own terms, it's ambiguous. Or it's not ambiguous, it's unambiguous that it wasn't offering to resolve the whole claim, but at best for McCarley, it was ambiguous. And an ambiguous 998 offer like this one cannot form the basis of an award of prejudgment interest.
But counsel, is there case law that allows a party to introduce extrinsic evidence to resolve any issue of ambiguity? And you stated that we don't have the letter in front of us, and that is because the plaintiff didn't have the opportunity to put it in the record because ambiguity wasn't raised.
There is case law to that effect in contract interpretation, that there can be a latent ambiguity in a document. But again, to the extent there's any ambiguity here, patent, latent, whatever, that would argue against enforcing the 998 offer against Dr. Canada. In order to support an award of prejudgment interest, the 998 offer would have to be clear on its face, and it isn't. So for that reason, the award of prejudgment interest should be stricken from the judgment if this court doesn't reverse with directions.
And so we've taken you beyond the time. I want to give you some time for rebuttal. So your briefs, of course, were well done, as were the plaintiffs. And so unless you were intent on talking about the two other issues.
No, that's okay. I'll reserve my time for rebuttal. Thank you.
All right. Thank you, sir. All right. On behalf of the plaintiff responded, Mr. Simonu, would you make
Yes, Your Honor. Thank you, Your Honor. Ben Simonu on behalf of the respondent, Stephanie McCarley. There's 4 issues in this appeal, but it's clear that the court's most interested in the 4th issue, so I'll jump right into that. As Your Honors point out, the first problem with this argument about the 998 is that defendants never raised that issue in the trial court and have waived it as a result. The premise is clear that parole evidence can be used to resolve any ambiguity in a 998 offer. That is a clear statement of law, and it's set forth, I think, most clearly in the Rodin case, 107 Cal App 4th, 620 at 624. So
let me go a little further with that. How does that law square with the fact that it is the obligation of the party making the offer to make it clear and unambiguous?
Well, because I think that this concept of ambiguity really is kind of a flawed notion in the context of a 998. I think that it has some application in a traditional contract sense, but it's strained here, and I can explain why in a moment. But let me take that question, Your Honor, head on and just simply say I don't agree at all with the premise that this offer was ambiguous. First of all, the law is clear that a 998 offer must be understood in light of the usual and ordinary meaning of the terms used in the offer. And according to Black's Law Dictionary, the definition of several liability is, quote, liability that is separate and distinct from another's liability. So as counsel read the offer, the whole point of several liability in this 998 offer was to make clear that the intent was to resolve the claim with Dr. Canada and not any co-defendants. And that's
the question, counsel.
Yes, go ahead. Go ahead.
His concern is joint and several liability that he might share with the other defendants. And his claim is that the 998 offer is silent, totally silent on joint and several liability. That's his point.
I understand that.
So he's saying it's ambiguous only in the sense that it does not dispose of the entire case because it doesn't reference joint and several liability as opposed to several liability only.
Well, and I understand that that's counsel's point, and I would say that that's an unreasonable interpretation of the offer because one of the doctrines of 998 offers is that they must be construed in light of the circumstances of the case. And in this case, non-economic damages were capped at $250,000. So if the premise
did he know that at that point? I mean, that's a good guess, maybe.
Well,
he wouldn't know that.
I'll tell you exactly how, Your Honor. Well, because of micro, obviously.
Well, I understand that. Yeah.
Yeah. So, and
that would be one's wishful thinking.
Well, I mean, the micro.
Did you oppose an attempt to reduce the damages to a micro level?
Did we hear?
Wasn't there a reduction of some of the damages to a micro level?
There was. There was, Your Honor. My understanding is that
was it opposed by Ms. McCarley?
My understanding is that it was unopposed, Your Honor.
Okay.
But I would also point out, and this is directly from the California Supreme Court in Rashidi versus Mosier, there the court said that settlement negotiations in medical malpractice cases, and I'm quoting directly, are based on liability estimates that are necessarily affected by the cap, end quote. And then the court went on to say, by placing an upper limit on the recovery of non-economic damages at trial, the legislature indirectly but effectively influenced the party's settlement calculations. That's straight from the California Supreme Court in Rashidi. So,
yeah, but it seems to me that's a bit of a red herring. We're looking at the four corners of this 998, are we not?
You are looking at the four corners of the 998, Your Honor, but the term several, I'll frame it as follows. We are saying
so what their concern is this. I presume that had they accepted the $1 million, they might have had to pay another $250,000 later.
Except for this, Your Honor, and this is where
that's what your argument amounts to, and then that's not a full settlement of the case, then, is it?
That's not what my argument is, Your Honor. In that context, let's play that scenario out. If they had signed the 998 offer and accepted it, and then we came back and said, okay, well, now we're going to come after you for the economic damages, the balance, they would have then said, well, wait a minute, this offer, we understood it as a full resolution of our liability in this case. And if it was judged to be ambiguous on that point, that's where the rule that says ambiguity is construed against the drafter, that's where that rule would come into play. And the court would say, counsel for McCarley, they would say, this offer, maybe it's ambiguous and therefore that's going to be construed against you. But this premise that the offer was ambiguous as to whether or not it was a complete release of Canada is just not consistent with, among other things, the circumstances of the case, not to mention the fact that...
What would have been the difficulty of simply saying the payment of $1 million will be a total and complete settlement against every claim of every type of nature against Dr. Canada? What's so hard about writing that?
Sure, Your Honor. I wish that it were written that way. I mean, speaking for myself...
I mean, that's just kind of common sense, isn't it? That's a common sense way to write a 998 offer because we know what it's supposed to achieve. So why would we leave the most important element, a total and complete dismissal of all claims, out of the offer?
Well, again, I don't necessarily think that that was left out of the offer, Your Honor, because the offer repeatedly...
Well, everything else is explicit except what's most important then. I mean, we're to infer it exists according to your argument.
No, I'm saying they could have inferred if there was any doubt, they could have resolved that doubt. I'm not
saying that's unreasonable.
I appreciate
that. Why should they have to infer something that's the most critical point?
Well,
$1 million is a lot of money. You ought to get something for it.
Let me respond to your question with a question, Your Honor, which is this. As opposed to...
We don't let you ask questions. That's the nice thing about it.
I think that's his way of arguing. Go ahead, counsel.
Yes. A rhetorical question, which is this. As opposed to simply inferring what the offer might have meant, if Canada had actually perceived any ambiguity and was actually interested in the offer, if in fact it meant a full release of his liability, what would have been so hard for Dr. Canada to simply reach out to McCarley's counsel and say, do you mean that this is a complete release, or are you only purporting to release my liability for non-economic damages?
Counsel, from my point of view, that begs the question. You could have as easily have said it resolves the entire case. I have to say, you used the term several in a way that, those of us who have done a lot of civil cases and personal injury, there is a very different context of what several liability means versus joint. From my point of view, the minute that I read that, I said to myself, so what happens to my potential liability for joint liability of all of the economic damages? That's the problem I'm having.
I appreciate that, Your Honor, and let me run with that for a moment. And just all of this is taking place in a hypothetical context, which is frankly largely a fiction, that Dr. Canada and his counsel sat around the table and thought, gee, we like this offer if it would be a full release and not only a partial release of the claims against me. That didn't happen. But if they were actually interested in the offer, it should have been incumbent upon them to resolve the ambiguity in the offer. Why? Because this concept of applying contract principles to 998 offers is limited by a more important principle, which is this. The purpose of 998 is to promote settlements in California. So if this court is going to say that if Dr. Canada and his counsel were actually interested in this offer, if it was a full release, and they yet did nothing to resolve any ambiguity as to what the offer actually meant, then we're discouraging settlements, because we want to promote settlements in a context where the parties actually are having a meeting of the minds, assuming that they're on the same page about what the offer means. But this rule that they're advocating for would allow parties to just sit back and slow play any ambiguity and raise it collaterally to attack a 998 after the fact.
Yes, that's exactly what the law provides they're able to do, if in fact there is an ambiguity and it's interpreted against the person making the offer. But let me ask you this. I think from their point of view, and this raises the other point that your opponent started with, maybe they weren't interested in the 998 because they don't think their client violated a standard of care. They're in effect two standards of care, that the 50 median level is also appropriate. And that may seem to be what was actually governing their thinking with respect to your offer. So maybe you ought to perhaps address that point as well while you have an opportunity.
I'd be happy to. I appreciate you giving me that opportunity.
Because they apparently seem to think that we're just supposed to take this entire verdict and go ahead and reverse it based upon the fact that there are two standards of care in this record. And I'd like you to speak to that if you would, please.
Absolutely, I'd be happy to. Thank you. So first and foremost, Your Honor had it exactly right, which is that the evidence in the record characterized the idea of a MAP of 50 as the lower level of autoregulation as an anachronism, as an outdated old paradigm that was based on bad data, animal data, in fact, and had been replaced, certainly by March 2013, with a different standard that recognized 70 as the safe lower level of autoregulation. So this concept that there was a debate is something that we dispute. I don't think the evidence supports that. And I would also say, and this is maybe the more important point that's being lost in this discussion here, this trial was never intended to be a determination of a one-size-fits-all lower level of autoregulation for the entire practice of anesthesiology forevermore. That was not the point. And that's not what the jury was designed to do here, or was asked to do here. The jury was asked to decide whether or not Dr. Canada acted reasonably under the circumstances of this case. Now, why is that significant? I'll tell you why. Because the only thing that could be offered by the defense in favor of a lower level of autoregulation is this premise that a lower level is beneficial in surgical procedures where there's a risk of blood loss, and having a lower level means the patient is less likely to bleed out if there's some sort of vascular issue. But this was an endoscopy. There was absolutely no risk of blood loss whatsoever. So the jury, having heard all of Dr. Wilson's testimony and seen the textbooks and recognizing that all of the modern data available to Dr. Canada militated very heavily in favor of a lower level of 70, the jury could sit there and say, why is he pushing the envelope with this patient in this procedure? Even if he thought 50 is still a safe threshold, why is he flying so close to the ground? Why not achieve or shoot for a level of autoregulation that affords this patient a measure of safety, a margin of safety? And he didn't do that. And there's no real justification in this case why. It's not like this was a vascular surgery where maybe he was concerned about blood loss. So the jury had all that testimony before it and could say, even if there is some defense for a level of 50 in some case, we're not having it in this case. We're under the circumstances of this case, we are persuaded by the idea that he should have shot for a higher level that afforded this patient a cushion of safety from a very, very severe injury, which is obviously a brain injury. So,
Counsel, we've asked you a lot of questions. We've taken you 3 or 4 minutes beyond your request. Justice O'Rourke and I have asked a lot of questions. Justice Doe, were there some things that you wanted to inquire of plaintiff's counsel?
No, thank you, Justice Haller.
All right. All right, sir. I'll give you 1 minute if there's something you feel that you really need to address.
Well, I think I hit it, Your Honor, with respect to that issue on the standard of care and why I think even this concept that there's a debate is really a red herring and frankly doesn't disturb the verdict. And I would just simply end with the point that I think is maybe most important with respect to the 998 offer, which is this issue was not raised in the trial court. We were deprived of the opportunity to present our record that would have clarified any ambiguity in the offer. The purpose of the 998 is to promote settlements, and had they raised this ambiguity, either it would have been clarified for purposes of the trial court's analysis and therefore this court's record, or if they had raised it contemporaneously with the offer, perhaps they could have taken the offer at the time and none of this would have ever happened.
Thank you, sir, very much. And Mr. Dixler, you have 3 minutes, sir.
Thank you, Your Honors. Subject to any questioning the court might have about all of the issues in this case, I'd like to focus in on the 998 issue first on rebuttal. Counsel mentions correctly that the law favors settlement. That's true. But that policy isn't served by enforcing ambiguous 998 offers. And here, at best for McCarley, the 998 offer was ambiguous. And as Justice Haller pointed out, in the context of personal injury litigation, the most natural reading of the offer on just by its 4 corners, and counsel concedes that a 998 offer is evaluated just on the 4 corners of the document, the most natural reading is that it offered to settle part of McCarley's case against Dr. Canada, but not all of it. The defense could have written to opposing counsel to clarify the offer if they had decided to do that, but there's no obligation to do so. Instead, the obligation is on the 998 offerer to present a clear offer. And having failed to do that, they're not entitled to recoup prejudgment interest. Justice O'Rourke asked whether the application of the microcap was a contested issue. And to answer that, I would point the court to volume 1 of the appendix, page 286, and that's the judgment in this case, which was prepared by plaintiffs and signed by the court. That the judgment says, where it's applying the microcap, it says the court notes that the jury's verdict included $1 million for past non-economic damages and $4 million for future non-economic damages. Based on the provisions of Civil Code section 3333.2, the court hereby limits over objection by plaintiff the amount of non-economic damages down to the micro limit. So that was in the judgment. So there was no, it was premature for.
So may I ask, sorry, this is Justice Doe. I see that in your reply brief, you argued that the applicability of micro was not established or known at the time the 998 offer was extended. Could you help me understand what was actually unclear? Was there really a dispute that the defendants here are healthcare providers and this was a case of professional negligence as opposed to ordinary negligence within the meaning of micro?
It wasn't a hotly disputed issue in the litigation, but the fact remains that it was the other side's burden to establish the applicability of micro. And again, at best for McCarley, that could generate an ambiguity as to what the offer means. There's no rule of law that precludes even a plaintiff undisputedly subject to micro from asking for more.
There's ambiguity if there are two reasonable interpretations. And is it a reasonable interpretation that if there was not a serious dispute that micro applied here, that the plaintiffs would be extending an offer that was 4 times the statutory maximum under micro?
Yeah, Your Honor, it's still ambiguous at best for McCarley. And the reason is that McCarley was entitled to ask for whatever she wanted to settle the case. There's no rule of law that says a plaintiff undisputedly subject to micro can't ask to settle non-economic damages for more than the microcap. A defendant could settle cases for any number of reasons unrelated to the merits of a case. The defendant might want to avoid bad publicity, avoid the expense of trial, et cetera, and for that reason could theoretically settle a case for more than the micro limit of non-economic damages. So again, that might mean, the language on its face most naturally points to the interpretation that she was offering to settle only non-economic damages. The presence of the microcap, I admit, could generate an ambiguity on the issue, but that doesn't help McCarley because she's entitled to prejudgment interest only if the offer was unambiguous, and that it wasn't. The extra record extrinsic evidence that opposing counsel is pointing to doesn't change that. Again, extrinsic evidence can explain an ambiguity in contract interpretation, but the fact remains that it's only relevant when there's an ambiguity or to identify the presence of a latent ambiguity in language that otherwise appears unambiguous. But extrinsic evidence cannot convert ambiguous language into unambiguous language, and the language has to be unambiguous in order to support an award of prejudgment interest. Finally, the letter, which again isn't in the record, but I direct the court to page 64 of the respondent's brief where opposing counsel describes what the letter says. What opposing counsel says is that the letter offered to dismiss Dr. Canada's employer, ASMG, for a waiver of costs. That talks about ASMG, but it doesn't talk about Dr. Canada. The offer was very clear about what McCarley was offering to Dr. Canada, or at best it was ambiguous, but it said it's offering to settle Dr. Canada's several liability only for $1 million. And that does not suffice to terminate the litigation against Dr. Canada. The 998 offer is invalid and cannot support the award of prejudgment interest. On the standard of care issue.
Well, you have 1 minute.
Yeah, in my final minute, I'll address the standard of care issue. It's certainly true that plaintiff's experts said that in his opinion, the standard of care required a map of 65 or 70, and that in his opinion, the traditional view that Dr. Canada adhered to, the map of 50, was an outdated paradigm. That's all evidence that McCarley introduced. But in the medical malpractice context, the question isn't which side of a debate among medically accepted alternatives has the better of it. The issue instead is whether a debate exists at all, such that, and in other words, to be liable for malpractice, a doctor has to have made a mistake that no reasonable doctor would have made. But whereas here there's a debate as to accepted measures of treatment, adherence to one side rather than the other side cannot yield medical malpractice liability. So for that reason, this court should reverse with directions or order a new trial. Failing that, at a bare minimum, this court should strike the award of prejudgment interest from the judgment. And unless the court has any other questions, I'll submit.
All right, there are none. Counsel, to both of you, thank you very much. This was very helpful. Thank you. The matter is submitted.
Thank you, Your Honor.
Thank you.
And we will now hear Vendor Surveillance Corporation versus Henning. And this panel, I again will be presiding, and I'm joined by Justice Dato, and Justice O'Rourke is still on the panel as well. All right, then for appellant, would you please make your appearance, please?
May it please the court. My name is Jack Shulkoff, and I represent Appellant Vendor Surveillance Corporation. The trial court made 3 errors below that warrant reversal. First, trial court erred in applying the ABC test to this case. The Dynamics case, while JanPro holds us retroactive, does not apply to our case because our case is not a wage order case. And Dynamics and its ABC test were limited solely to wage order cases. Next, the trial court misapplied
Was Dynamics limited to wage and hour, or the court said we're applying it in a wage and order, but that didn't necessarily saying they were going to not apply it in other types of cases, correct?
Well,
we went to the language of the statute.
I think that Dynamics was based, I think there's 2 answers to that question. First, Dynamics focused solely on the wage order and the definition of employee in the wage order and as sufferer permit. JanPro, which came out in January and holding that Dynamics is retroactive, held that and specifically said that in Dynamics they faced the question what standard applied in determining for purposes of the obligations imposed by the wage orders. And in holding that Dynamics was retroactive, the Supreme Court in JanPro said this was the first time that the Supreme Court had ever decided the meaning of suffer or permit and whether a person is an independent contractor under purposes of the wage order. And for that reason, under JanPro, the court held that it was retroactive. So unlike our case, where we have a specific Supreme Court decision, it's old, but we have a specific one in Empire Star Mines, which interprets what an independent contractor employee is for purposes of the unemployment insurance code. Whereas in Dynamics, it was the first time the court had interpreted what employee means under the wage orders. And so Dynamics cannot be retroactive if it applied to prior decisions. And in fact, in JanPro, the court made the point that in Dynamics, the court did not overrule Borrello, did not overrule Tyberg, and did not overrule Empire Star Mines. Because in all of those cases, the court had already decided for purposes of either the unemployment insurance code or the workers' compensation rules what an independent contractor was and what an employee was, but had not done so in the wage order context. It was an issue of first impression. So the trial court should not have applied the ABC test to our case because Empire Star Mines was the applicable authority and not Dynamics. And while Dynamics would be retroactive to wage order cases, it's not retroactive to other cases. And in fact, in JanPro, the court said that the reason it would be retroactive was because employers and lawyers couldn't assume what the meaning of the wage order was. Well, we don't have to assume what the meaning of the unemployment insurance code is because Empire Star Mines told us. The next error was that the trial court, as an alternative holding, misapplied the undisputed facts to the applicable Empire Star Mines factors. And in that case, in that instance, the court's primary error was its conflation of the format requirements with the actual inspection jobs. There was no dispute in the trial court at trial that the VSC did not, in the trial court's words, stand over the shoulder of the project specialists. The project specialists were very experienced people who knew how to do these source inspections, did it based on their experience and their talent and their education, and were not supervised really by anybody except themselves. Now, the trial court agreed with that, but said that the manner and means of accomplishing the source inspection job involved preparing a report. Now, the Varisco case, which we cited in our papers, is really on all fours with this case, because in that case, there was a construction inspector who went to LAUSD working for a construction inspection company, and he was required to inspect sites to make sure they complied with certain regulations and rules. However, he was supposed to fill out his report using LAUSD forms. That's no different than what the project specialists were doing in our case, that they either had to use a client's portal or they had to use a client's format in producing the inspection report. But the actual inspection work was solely themselves. And so the manner and means of accomplishing the inspection was not supervised by VSC. And I think that the fundamental error that the trial court made was in ignoring or misapplying Varisco. There's two other cases that we cited in our papers, Mission Insurance and Beaumont Jacques, all of which involved situations where the principal provided, in the case of Mission Insurance, that's the alarm contractor, he wore an alarm shirt that identified himself as being with the alarm company. He was given tools by the alarm company, but at the end of the day, the alarm servicing that he was doing was based on his talent and his judgment and his control. And so what I think, what we know from Empire Star Mines is that the primary factor, and this is also provided for in the unemployment insurance, the EDD's own regulation, 4304-1, that the primary test here is one of control. And then there's all these other factors which we can look at to help elucidate that, but ultimately it's control what is determinative here. And when the evidence is undisputed as the way it is in our situation, as to who's doing what, that the court should have found that the project specialists were independent contractors. I just want to...
This is Justice Dato, if I could interrupt you for just a moment. You focused on the control factor, and certainly it is correct that the case law talks about how that's the most important of a test that has any number of other factors which are to be weighed qualitatively. Would you agree?
Yes, there's no, you don't weigh by if you win on 3, then you lose on the other 7. It doesn't work that way. That's correct.
Right. And the trial court here went through all of those factors and in fact found quite a number of those factors favored the view that these project specialists were employees rather than independent contractors. Is that also fair?
I think that the trial court went through those factors and attempted to analyze them. I think that its analysis, even if all the evidence that it cited, it's undisputed, I think that its analysis was incorrect. But yes, it attempted to do that.
Okay. But focusing on the issue of control, isn't the evidence conflicting on the issue of control, and specifically with respect to the ability to discharge the employee?
No, I don't think that the evidence is disputed with regard to discharge. The contract between the parties, which was undisputed, specifically indicates that a worker could be, a project specialist could be terminated based on 30 days notice, or without cause, or the project specialist could leave, but there might be a financial penalty if they left before a job was done. And I would add.
I'm sorry. Could you talk about that one? Because to me, if you say either party can terminate without cause, but there's an exception with respect to a penalty that the employee or the project specialist is going to suffer, that's not exactly each party being able to terminate without good cause. It's attaching a fairly significant penalty to one side exercising that right. And doesn't that support the trial court's view that in terms of control, the evidence would point to the fact that these are controlled employees rather than independent contractors?
I don't think so, because I think that if we look at the cases, specifically, again, Varisco and Beaumont-Jacques, and in Beaumont-Jacques, that was the insurance district manager, and there was a 30-day notice provision there, and the court said that that did not create an employee relationship. And I believe Varisco said that while Empire Star Mines had previously talked about the discharge, it believed that independent contractors can, in this day and age, always be terminated at will, and either side. And so that the discharge provision is really not that germane the way it may have once been.
Well, that certainly wasn't this court's view in the Espejo case, was it? There was a 30-day notice termination provision there, and we pointed to that as being a significant factor showing the right to control the employee. Is that true?
That's in the Garcia case? I didn't hear which.
No. I'm sorry. Espejo.
It's the case involving the newspaper deliverers.
Yes, that's correct. But I think that that in most of the cases, and I understand that case is out there, that they look at the discharge provisions as being. I think that law originally comes, I believe, from Empire Star Mines. And Empire Star Mines, there was a 30-day provision in that case, a 30-day termination provision in that case back in the 40s. And the Supreme Court in that case still held those workers to be independent contractors. So I think that the discharge provision has changed and morphed over time to be much less important than the primary factor, which is control.
Counsel,
and I'd like to reserve. I'm sorry.
Good. I was just going to say, I neglected to ask you, but you've taken about 11 minutes, so we'll hear from the respondent. Thank you.
Thank you.
Good afternoon. This is Anna Barsakin for respondents. Under any reasonable analysis, an employment relationship exists between the project specialist and appellant, whether it be under Dynamex, Varelo, or the Unemployment Insurance Code. Thus, the trial court properly found an employment relationship existed. With regards to the Dynamex, the trial court properly held that Dynamex applies to this case. The dominant concern of courts has always been to be the fundamental protection of workers and not applying different classifications based on how the case arose. Worker classification has moved fluidly in unemployment insurance, workers' compensation, and wage and hour cases.
Well, this is Justice Dato. If I could interrupt you on that.
Yes.
That is certainly true that there's a relationship here, but the standard that the Supreme Court interpreted, statutory standard, regulation standard interpreted there, was the suffer and permit to work standard. That's not the standard that applies in the unemployment insurance tax context. Is that correct?
That is correct, Your Honor. The Dynamex decision specifically determined the ABC test based on the wage orders. However, it did leave open to whether the ABC test could apply in the unemployment insurance context. Specifically, the court discussed a legislative purpose test where it said that we should look at the purpose of the purpose of the statute and its remedial nature to determine whether an employment relationship exists.
That's an issue that was left open, and then we have the Supreme Court coming back in Vasquez and saying we're going to apply the ABC test retroactively in the wage order context because we've never spoken on that before. Whereas you can't say that with respect to the unemployment insurance tax context because Empire Star Mines itself involved the unemployment insurance tax. Is that correct?
It did, yes. Empire Star Mines did involve the unemployment insurance tax. Although it's not determinative, the court did not specifically hold that the ABC test applies to the unemployment insurance context. The court did note that Dynamex drew on factors articulated in Borrello, and it wasn't beyond the bounds of what an employer would reasonably would have expected. The Dynamex test, the ABC test, focused the standard into three factors instead of 10. It refined Borrello, and by applying a more focused standard in this case, it would effectuate a more meaningful purpose to the unemployment insurance statute by providing reducing any sort of worker misclassification and allowing workers who are properly employees to be able to access the benefits of the unemployment insurance code.
Counsel, what's the significance of the language under 621B that these individuals are to be evaluated according to, quote, usual common law rules of whether there is an independent contractor or an employee relationship?
Our position is that at the time of trial, Dynamex was applicable common law and that Dynamex should apply because it would not be inherently unfair to apply the Dynamex position. But even so, even if Dynamex doesn't apply, the court went over the factors, the 10 of the Borrello factors, and a majority of those factors it found supported an employment relationship. So regardless of what standard is used in this case, an employment relationship exists between the project specialist and appellant.
That's a different issue. Now we've switched to even if Dynamex doesn't apply, they meet the Borrello factors, right?
Yes,
Right.
Your Honor. They do meet the Borrello factors. There was significant right to control the project specialists in this case. The trial court found that VSC and Verify were a business enterprise. So VSC screened the prospective project specialists. The project specialists were required to take several quizzes before they were even assigned they were given an assignment. They were required to report to VSC with their time and expenses. VSC paid the project specialists, and if there were any issues that came up with regards to customer dissatisfaction or any other issue, it was VSC that resolved those issues, and it wasn't the project specialist. Additionally, the project specialists were not free to substitute any other individual for the services that they performed under the contract with the Verify clients. They carried around VSC business cards. There was a significant right to control, which the trial court probably found. There was substantial evidence to support that finding. Even though the VSC was not there when the inspections were occurring, they still had a significant right to control. There was some level of freedom allowed or inherent in the nature of the type of work that project specialists did because they had skill. However, VSC exercised pervasive control of the operation as a whole. They had the right to hire and to fire these projects, to terminate the contracts of these project specialists. The court mentioned the right to discharge. I did want to mention some of the cases and distinguish some of the cases that the appellant brought up. With regards to Verisco and the Beaumont-Jacques case that the appellant mentioned, these cases are factually different than this case. With regards to Verisco, plaintiff reported to LAUSD and did not report to the defendant, which is Gateway. If there were any issues that came up, it was plaintiff went to LAUSD and not Gateway. And Gateway did not know the operations, did not know what exactly the plaintiff was doing. So there wasn't a right to control, and definitely Gateway did not exercise the right to control in that case. So that case is factually different from here. With regards to the Beaumont-Jacques case that appellant mentions, there was factual distinctions for that case too. The plaintiff over there was an independent contractor and had a staff which she supervised. She resolved any of the problems that came up. So she had a significant right to control in the operation of her business. That is not the case here, as the trial court found. The trial court properly found that there was substantial evidence that VSE had pervasive right to control the business and the inspection and the reports that the project specialist provided. With regards to the Borrello standards, not only did the court find that the right to control, that VSE had the right to control, but it also found that the majority of the Borrello factors supported an employment relationship. And I'll just go to some of the factors. The workers were not engaged in a separately established business. Although there were some workers that may have had a separate business, they were not really engaged in it, and they did not. For those workers that were working for VSE, they did not directly negotiate with the VSE clients or verified clients. So, in fact, there really was no negotiation going on with regards to their work for VSE. The clients...
Counsel,
yes.
You know, in your briefing, you certainly pointed out the Borrello factors that the court found in your client's favor and the reasons why. So is there anything that you wanted to supplement on that? Because we have certainly read your briefing, and it sounds like you're kind of going back over those points.
Yeah. Well, we just wanted to, the one other thing that I wanted to mention, even regardless of the Borrello factors, the unemployment insurance codes would still support an employment relationship with the project specialist and VSC. And that would be unemployment insurance code section 606.5B. So under any reasonable analysis, there's substantial evidence that the project specialists were VSC employees. The trial court weighed the evidence and assessed witness credibility. There was 23 witnesses that testified at trials. There was more than 25 exhibits that were admitted into evidence. And the trial court properly concluded that an employment relationship existed. And if there's no other questions, I will rest.
All right. Any questions from the panel? There appear to be none. Okay, then let's hear from the appellant again. And counsel, you have about 3 minutes left.
Thank you. I just want to follow up with regard to the Ayala case. There is another case that we cited in our papers, and I'm going to botch the name, but it's Pergusa versus Industrial Accident Commission, 29 Cal 2nd 857. So it's a Supreme Court case from 1947 that acknowledges that while an employee may quit, an independent contractor is legally obligated generally to complete the contract, which is effectively what the financial consequence if the project specialist leaves. That's consistent with if you have a plumber and they leave the job, they're going to be responsible for paying you to complete the job that they had agreed to complete. So if anything, the contract would lean further towards the independent contractor. Also, with regard to the alleged, again, I just want to emphasize that all of the Borrello factors are ways to show control. And in our case, control is we believe, pretty self-evident. And one of the things is with regard to controlling the inspection activity is there was evidence that VSC itself never actually reviews the report. That's at the reporter's transcript, volume 2, 346, 22 to 24. So this isn't a situation where VSC is reviewing inspection activity in any case. And then finally, I think that ultimately the trial court, in reviewing all of these factors, got lost in them and got lost in what it was really trying to find out is who controlled these workers. And I think that the trial court, by getting kind of tangled in the Borrello factors or the Empire Star Mines factors, lost the, I don't know if it's the forest from the trees or the trees from the forest, but lost the ultimate goal here, which is who is controlling the inspection activity. And the project specialists, all of the evidence was that the project specialists themselves determine whether the parts are in compliance. And that was what their job was. That's what they were engaged to do. And VSC did not control that. And finally, there were no findings by the trial court about whether, no specific findings, whether Verify and VSC were unitary businesses. So we believe under 621B and the unemployment and insurance regulations and Empire Star Mines, that trial court erred its decision that the project specialists are employees is wrong as a matter of law and should be reversed.
Counsel, thank you very much. The matter is submitted, and we will take the final appeal on today's calendar. Thank you.
Thank you.
Thank you.
All right, I see that Justice Doe has rejoined us. So in the matter of DLSC versus Built Pacific, I will be presiding again I now joined by Justice Dato and Justice Doe. All right, counsel for the appellant, if you would like to begin, and do you wish to reserve some time, sir?
Yes, Your Honor, I'd like to reserve 5 minutes, please.
All right, that'll be fine.
May it please the court, my name is James Diefenbach on behalf of Appellant Built Pacific, Inc. We're respectfully requesting this court to reverse the judgment based on a finding that the settlement agreement between the DLSC and Built Pacific contained an unenforceable liquidated damages provision pursuant to Civil Code Section 1671, subsection B. The DLC in its opposition tries to focus on the fact that the judgment itself was entered under Labor Code 1742, and they also basically try to just divert any attention from the actual document signed between the parties where there was a dispute and a lesser amount was agreed upon between the DLSC and Built Pacific to settle the claim. And the language of 1671 is clear, and there are exceptions, none of which this agreement falls under. And 1742 from the Labor Code does not provide any relief under that section, providing that it would not, this agreement would not apply. This document has to be a settlement agreement. And again, as pointed out, you've got multiple appearances of language regarding the settlement sum, the release of claims between the parties. And essentially, it acts as a stipulated judgment where now the DLSC gets the entire amount of its claim if the payment is more than 1 day late, which again flies in the face of the relevant case law and the Viatech decision and the Green Tree Financial decision as well. One of the arguments raised by the DLSC is that 1671 A would prevent this subsection from applying because Labor Code Section 1775 and 1777.7 address and fix the damages. And the DLC is conflating the issues, whereas you look at the specific language of 1671, the type of statutes that prevent or apply to subsection A are those that specifically address the liquidated damages stemming from a settlement. The statute cited by the DLSE fix the penalty, not the settlement of a penalty. And I cited a number of examples in the brief. You know, they deal with things where a default of a home purchase agreement or a consumer agreement, they fix the exact amount of liquidated damages in these types of transactions. The statutes cited by the DLSE do not address penalties or how they tie to a breach of an agreement between the parties for a compromised amount of this claim. When you look at whether or not the penalty is unreasonable, it is absolutely unreasonable pursuant to the other case law that look at cases under 1671, because again, as previously stated, this allows the DLC to get 100% of the maximum amount it could have recovered in the event the penalty is 1 day late. And the whole purpose of 1671 is to prevent settlement agreements that have penalties that don't have any relationship to the harm caused. Here, the payment was received 36 days late from the general contractor for this dispute. And at most, this is an interest claim. There's no bearing between the approximately $70,000 policy and receiving the payments 36 days late.
Counsel, this is Justice Doe. Is that a fair statement of the record? You say that the payment was 36 days late coming from Austin Sunt. Isn't it true that BPI has never made a payment? That was a payment by the prime.
I'm glad you brought that up, because that was my next point. I routinely handle transactions for civil wage penalty payments where a third party makes the payment towards the civil wage penalty assessment. The civil wage penalty assessment names multiple parties, including the owner, the surety, the general contractor, and the subcontractor. And
in this case, Austin Sunt made that payment pursuant to its own settlement agreement that did not include a release of BPI, correct?
That's correct, Your Honor. However, the DLC did provide credit towards the amount that BP owed, and the funds were used were BP's funds. They were the retention that was withheld from BP. So the whole point of whether or not Bill Pacific does not have to be the name on the check. Once the DLSE receives the payment, they credit this civil wage penalty assessment. The parties are jointly and severally liable, and yes, you are correct. This payment was made pursuant to a separate agreement, but the reality is that once Bill Pacific withdraws its request for review pursuant to the first settlement agreement, the DLC, recall Austin Sunt did not file a request for review, so they could have been liable for the whole amount. So the reality is the parties are jointly and severally liable, and BP's agreement did include a release for Austin Sunt, and BP was credited towards the amount it was owed from the Austin Sunt payment. So the notion that somehow BP has to be the name on the check is just not the practice that occurs often. Oftentimes, I have personally been involved in at least half a dozen settlements where the surety pays on behalf of the subcontractor and the matter is resolved. Now, granted, these cases, the payments were received before, and that's what the dispute is. But the settlement sum for this civil wage, because there's one civil wage penalty assessment that governs the entire, each of the three periods. And the payment from Austin Sunt is applied towards that debt. So I would respectfully submit to this court that Bill Pacific does not have to be the undersigned to provide the settlement payment. The real issue is whether or not, and also I would add, Bill Pacific did write a check for $70,000 for the penalty amount. So Bill Pacific, and I can't recall the exact date, did write a check for $70,000 to satisfy the 100% of the original civil wage penalty assessment, which was approximately $154,000, based off of this. Essentially, it's a stipulated judgment where the DLC is trying to circumvent 1671, because if you're
if you could help me understand that better, counsel. You argue that the judgment was entered based on this settlement agreement. And why is it not a judgment entered based upon the CWPA and the Public Works Law? The request for entry of judgment attached the CWPA, and that's what the trial court had, not the settlement agreement.
Correct, Your Honor. So the DLSC did enter judgment pursuant to 1742, but I would submit to this court that that is not the appropriate method to submit the judgment. Basically, the reason why it's entered is because the settlement agreement provides DP will withdraw its request for review, and if in the event there's a default, DLSC gets to submit the judgment for 100% of the original, use QAPA, so if I use the term QAPA, I'm referring to civil wage penalty assessment. You can submit for 100% of the original QAPA. And in effect, this is just a workaround to allow them to collect 100% because the penalty clearly has no bearing to the relationship of being late. And so I would submit to this court that the judgment should not, it was improper for the DLC to submit the judgment under 1742 because of the existence of this settlement agreement. So that is the problem and one of the reasons why the trial court, I believe, got hung up on.
Can I interrupt you there, Mr. Diefenbach?
Yes.
Because that's what I'm having some trouble with here. If the settlement agreement was designed to preclude the DLSE from submitting the judgment pursuant to the Labor Code statute, why wouldn't it say so? And having not said so, the fact that there are essentially two parallel ways to get to the result, they chose the one that was provided by the statute. Why does that implicate 1671?
Yes, and I may have misspoke in that I wasn't trying to state that the settlement agreement prevented them from doing that. But to answer your question, Justice Dato, my point is that 1671 applies to the settlement agreement. And what the DLSE is doing is they're saying, don't pay attention to the bargain that we struck, the deal where we reduced the claim. We're going to go back out and enter it pursuant to 1742, where we can now seek 100% because we've required you to withdraw your review in order to get this deal. And then once you're a day late, we can just enter it under 1742. So the problem here is that it undermines Bill Pacific's, it undermines the statute, the legislative intent of the statute by allowing the DLSE to strike a deal with a contractor. And then if you're a day late, they get to go back into 1742. The problem is 1742 and the rest of the legislature under the Labor Code are silent as to whether or not what happens when you have a settlement. And the DLSE says, oh, this isn't a settlement, it's a release. But the reality is, and when you look at just, Black's Law Dictionary or basic terms, this is a release and settlement agreement between the parties to reduce liability and exposure because both parties had risk at a hearing of either getting a 0 or a full 100% of the judgment. And so there's nothing in the Labor Code that prevents 1671 from applying. There's nothing in 1671 that prevents it from applying. The legislation could have wrote in, this does not apply to the Labor Code. This does not apply to these specific sections, but it didn't. And really, this is a problem with the system, that the way in which the DLSE is operating, where they get to have penalties for being days late that have no bearing to what the harm is to the workers who are ultimately receiving these wages.
Okay, can I stop you though, because I think you answered my question. My question is that if this is the procedure that's in place, and you're pointing out how this parallel mechanism is unfair, why isn't that the subject of an appropriate agreement between your client and the DLSE, where you say, listen, I don't want to enter into this settlement agreement unless I have some protection that you're not going to do this. And so I want to put a clause in it. Why isn't that the way to deal with it?
Yes, and Your Honor, I would certainly invite you to ask Mr. Grisell this. I have tried numerous times to negotiate clauses with the DLSE. They will tell you that it is an absolute policy not to amend these form pleadings. It is the exact written language in there. I've had this exact, not this exact, but I've had other arguments that have been very important to my clients about withdrawing the review, because the whole problem for the contractor is once you withdraw the request for review, oftentimes this is well after the initial award was, so you can't just reinstate the award. So the contractor has absolutely no bargaining ability in the terms of this agreement. If you want this deal, you have to sign this paper. And if Mr. Grisella has ever modified one of these, I would be very interested to know why. But I have tried on multiple occasions to negotiate these. They do not negotiate. And if you compare the two agreements, they are the exact same, other than the names of the parties. Even the amounts are the same. So the reality is, and that's part of why it's an unreasonable penalty, because the contractor doesn't have the ability to negotiate any terms in these proceedings.
Right, counsel, we've taken you to your time, but Justice Doe, did you have a question still pending?
No, not at this time. Thank you, Justice.
All right,
Henning.
okay.
Thank you.
All right, then we'll hear from the respondent.
Good afternoon, Your Honor. Lance Grisella on behalf of the Labor Commissioner, Division of Labor Standards Enforcement. The judgment entered by the Labor Commissioner is not enforcing a settlement agreement. We heard from counsel, the brief, BPI's brief begins by stating that they're objecting to the judgment on the basis that the settlement agreement contains this unenforceable liquidated damages clause. Our position is that that release agreement is irrelevant here, essentially. That once they didn't perform one of the two conditions precedent that were in that release, which is otherwise self-executed, when they do two things, withdraw the request for review and pay a certain amount. Once that didn't happen, we're not concerned with that release agreement anymore. It never happened. In other words, the release never took place. So at that point, we are left with whether or not they reinstated their request for review. It is not true that they cannot do that. In fact, that is one of the main focuses in the briefing. I'm not going to get into that, but I would just say, I mean, unless there's questions, obviously, from the court, but what I would say is their position would render the regulation and the statute that provides for that situation completely meaningless. There's
Counsel, I am going to ask you to go into that. So your position would be that once, for lack of a better term, the two of you came to a settlement. And the settlement provided that if you're late or you don't pay, then we revert back to the total amount of the assessment. And your position is that when they breached that settlement deal, they, Built Pacific, had the right to request review again of the assessment. Is that the same?
In this particular case, they did before they did not pay. And let me explain, okay? Because in this case, and this was, I'm trying to, I really don't want to get into detail about what happened that isn't on the record. There's kind of some of this discussion that happened in the briefing. But to be candid, the 90 days that they had to pay is unusually long. The work here was done in 2014. We were very motivated and trying to get money, the wages in the workers' pockets, and it was delayed for years because of this side dispute between Austin Sun and BPI. And finally, when we reached that agreement, they wanted 90 days to pay because, as we can see from some of the exhibits that were attached to their briefing below, there was this ongoing dispute that plagued this case from the beginning, and they needed time to sort it out. Now, they got 90 days to do that. So what that meant was there was actually an additional 30 days, it's true, beyond which they were not able to reinstate the request for review. However, I pointed this out in my brief, and there's evidence in the record where there was some communication you can look at that they were at least not certain that these contingencies that were irrelevant to the agreement between us, BPI and DLSE may not have happened. In other words, there was a warning, I would say, that it wasn't going to go as planned. So what I'm suggesting is they could have absolutely, within 60 days of the withdrawal of that request for review, just submitted a request to reinstate it, and the hearing officer would have considered that request. Now, they didn't do that, which is critical here, because our position is that the statute is actually functioning absolutely as intended. The statute was, Davis Moreno talks about this in the case. The statute created the legislature created an administrative process for the Labor Commissioner to effectively enforce the prevailing wage law, and it did exactly what it was set out to do and accomplish here. The Section 1671 was not created to protect unscrupulous contractors from their liability under the prevailing wage laws. So our position is that the DLSC took steps that were in accordance with this statute and consistent with the statutory charge to enforce the labor laws, including the public works laws, and to make sure that these workers got paid as soon as possible. Again, just to circle back, once that amount wasn't paid, and in other words, they didn't perform, yes, there was a contract. They sort of insinuate that we won't agree that there was a contract, but that becomes irrelevant. Okay, and the reality is that they were unable to withdraw or reinstate their request for review at that point. And again, that is because of a kind of sort of unique situation here where they wanted extra time. The reality is that they didn't make any payment, and we started off this discussion with the argument that there's payment was 26 days late. I mean, that notion is ridiculous, to be quite frank. It comes up over and over. The reality is that Austin Sunt's agreement with DLSC after they failed to make a payment had nothing to do with BPI. BPI is trying to have its cake and eat it too here. I mean, it's not unconscionable that they're responsible for a lesser portion of this, as it turns out, than they would have been if they were able to, make the agreement at first. And that agreement, I would point out, there's no indication that that's based on a risk. In the reply brief, it sort of insinuates that there was this calculated risk. The purpose of that is that, first of all, there's a resources issue and a time issue. And so the fact that DLSC agreed to accept a reduced amount of penalties in response or in order to avoid having to litigate at a hearing, having to wait for a decision and the hearing to proceed, that doesn't have any bearing on the case. And in fact, when they signed the release, those were not arbitrary penalties or this penalty. The amounts were specified. They were all specified in that document. They knew they were agreeing to pay the wages. They were agreeing to pay penalties. They were even agreeing, ironically, to pay a portion of liquidated damages. I went back to verify that earlier. It's right there in the paragraph. And the fact that they didn't, basically, again, that's when that became irrelevant. And then the statute exists. There's a protectionary statute. This civil code statute has nothing to do with the prevailing wage law. And there's nothing that would allow it to interfere with the labor commissioner's valid exercise of state police powers in enforcing those laws. The fact that it claims to have contested the QAPA at all times, we also would dispute. Again, the amounts that were agreed upon in the release agreement are specific. It's not an arbitrary penalty. And all of the amounts are statutory. And that gets to the case law, which there really is none to support their position. I give them credit that they found the only viable basis, I think, in all of the underlying litigation, which I was handling, to polish off and bring to this court. But it just doesn't apply. All of these cases involve private contracts between two private parties. None of them involve the government's enforcement and exercise of its police powers. You have cases where they are, one of them involves a loan agreement. The other is a settlement where there's non-admissions clauses. And it's not an accident that language that was brought up earlier by Justice Dato is not in this agreement. I'm not going to stand here and pretend that it's not purposeful that we will use the prevailing wage statute that, again, Davis Moreno explains. There is now an administrative process. 25 years ago, a colleague who's doing my job would have to file a civil lawsuit each time to collect these workers' wages and the penalties that are provided in the statute. That doesn't have to happen anymore. Why? Because we have this statutory scheme. And in order to now take that away just because there was going to be a compromise would just fly in the face of all that the statute stands for. I'm sorry, I just want to check that you can still see me because I've had several people disappear on my screen. Can you see and hear me still?
Yes, I certainly, I believe we can all see you.
Okay. Okay, thank you. Sorry, there was like
No
things
problem.
have been flashing. So anyhow, like I said, the case law doesn't support. It's inapplicable here. It doesn't. None of them are on point. They involve a totally different scenarios, and they have. You know, if someone filed, like for example, the Viatech case, you have a case where it's like, well, it's unfair for DLSE to get everything they claim. This is not a lawsuit where DLSE made up, said, oh, I'm going to sue someone and decide how much to claim. Well, okay, $10 million, right? We're going to start there, and we're just going to make a stipulated judgment for $10 million if they pay a day late. That's not what happened here, okay? There was an investigation. There was evidence. We were confident in our case. Again, the compromise was not because of any sort of risk. Again, the wages were earned in 2014. And because BPI and Austin Sun, which again, we have this glimpse into their horrible, relationship that slipped into this, horrible situation, basically caused all these delays. And we wanted to get the wages into workers' pockets as soon as possible. And for that, we were willing to compromise on those penalties. And just because we did that doesn't mean that now all of a sudden we're required to go into court and enforce this release that, again, it becomes irrelevant once both those conditions aren't satisfied, and enter it and sue them. That wouldn't make any sense because the whole point of the prevailing wage law now with the administrative process we have is that we don't have to file a lawsuit. And so, again, I'm circling back to the point that the law actually worked here. This is where and the prime contractor, I'm not going to talk about other cases. Each case is different, as we can see here, and there's different facts and different circumstances. But it is true that one other thing I would point out is I can't square the fact that we, in the briefing below, they're arguing that DLSE should have had to enforce this as a contract. We didn't do that, and they're admitting that. So if that's true, and we didn't, then how is their argument that we're enforcing a liquidated damages clause in an agreement that we're not enforcing something that this court even needs to look at? It would be moot, right?
So just to give you a heads up, you have about a minute, and I think you said we're circling back, and I think we are hearing arguments cumulatively. And repeating things we've already said.
I hear you. Okay, well, I would just sum up then that basically there's no basis in the law that provides for this civil code here to apply to these circumstances, and that the labor commissioner acted within all of the statutes, and that the law accomplished what it was set out to do, as pointed out in Lusardi and Davis Moreno. And I will, unless the court has any questions, I will submit.
Thank you, sir. Okay, let's hear again from Built Pacific, please. You have about 3 minutes, counsel, for rebuttal.
Thank you, Your Honor. Just a few brief points. First, you heard counsel say that in this case, we would have been past the 60 days to request review. So Built Pacific could not have requested review at the time the payment was due, or they knew the payment could not be made. Second, there's discretion from the hearing officer. So the request for review was not even had they requested it within the 60 days, it was not certain that it would have been granted. Regarding counsel mentioned that there's no authority that states that the civil code applies to this and tries to distinguish the cases, but that argument cuts both ways because there's absolutely...
I'm sorry to interrupt. Could I just circle back to what you just said about BPI not having the ability to request reinstatement?
Yes.
The settlement agreement was reached in February of 2019, I believe, and 60 days for you to seek reinstatement of your request for review would have been in April, right? And then the agreed upon deadline was BPI was to pay by May 9th. Is that correct? Do I have my dates correct? Justice Holler, I think counsel's frozen.
Yeah, I was going to say we.
I'm sorry, I'm back.
Okay, you are back. Okay.
Freaking out there for a second. You were saying that basically the 60 days would have expired in April.
Well, I just want to make sure I understand the dates here. So the agreement was reached in February 2019, yes. And your deadline to pay was May 9, right?
Yes.
So you had 60 days, and I assume, BPI was advised by counsel, so BPI knew that the CWPA would become final before the deadline to pay. So if there were issues that BPI was encountering, couldn't you have just avoided this by either paying the payment by the deadline agreed or seeking the reinstatement of your review request?
Yeah.
Counsel, we're having a problem. We keep losing you. I'm going to offer you either.
I'm going to call in.
Yes, that'd be fine. We'll wait for you to call in.
All right. I'm so sorry to the court. I will call in right now.
No, it doesn't matter. We have these problems with some regularity, so let's just get you on the telephone so we can hear you.
All right. Just give me 1 second.
Sure, of course.
Of course, since it appears to be working now, I will just weigh in. Yes, Your Honor, I know Built Pacific wishes that this amount had just been timely paid. Then we would not have any issues. We wouldn't be here today if Built Pacific had issued a check prior to May 9th. The problem with issuing a request for review would have been that it would have been violation of the settlement agreement, because part of the terms of the settlement agreement was to withdraw the review, and therefore that would have jammed up the process. We can get into all the facts about why Built Pacific didn't make payment, and that's kind of not really before this court. But at the end of the day, and one of the key things that I wanted to stress to this court, I think I was just saying, or before Justice Doe asked her question, was that the authority issue that counsel for respondent brings up cuts both ways, because there is absolutely no authority that states that 1671 somehow does not apply to the labor code. And there are express exceptions contemplated by the legislature under which do not cover the umbrella of the labor code or 1742. And one of the big points that I want to make to the court is, as counsel brings up, this prevents the intent of the prevailing wage code to allow for the ease of enforcement of judgments. And I would submit to this court that if what should have happened here is the penalty for a late payment, as long as it's tied to what the harm is to the workers, which would be interest or other delays from whatever the late payment is, that would be totally acceptable. And they could have done this where you allow a stipulated judgment to be entered into the court and collected upon without having to go through the rigors of a new civil trial. So there are absolutely mechanisms available to the DLSE, had this been framed differently, to allow for ease of collection for a legitimate amount. The problem is not the judgment of itself, it's the amount of the judgment. And 1671 speaks to the amount of the judgment being improper based on there not being a tie between the $70,000 for being a day late versus the $83,000 that was agreed to by the parties. There has to be a nexus there, and the DLSE has failed to prove in any way that 1671 should not bear and apply to this settlement agreement between the parties. Thank you.
All right, then, counsel, thank you very much. And the matter is submitted, and we will be in recess until tomorrow morning. This was helpful. Thank you, counsel.
Thank you, Your Honors.